The Constitutional Court has ruled that the South African government may not conduct bulk surveillance on citizens. The court says any bulk surveillance within South Africa is unlawful, and that upholds a previous decision made in a High Court judgment. The case specifically revolves, should I say, around the regulation of interception of communications and provision of Communication-Related Information Act. Let's call it RICA, with the court ruling that this legislation is unconstitutional. It's all a mouthful, isn't it? Well, I want to explore the implications further with Jane Duncan from the Department of Journalism at Wits University. Jane, good afternoon to you. So try to simplify this for us if you can. At the heart of this matter, I understand, is the right to privacy, and particularly as it pertains to some practices regarding the media.
Good afternoon, Jeremy. And just a correction, I'm with University of Johannesburg, not Wits University. I think specifically in relation to the point that you've picked up on, because obviously there's 6 areas that the Constitutional Court picked up on in relation to RICA and bulk surveillance. But the area that you've picked up on concerns the ability of the State Security Agency through its National Communications Centre to scoop up huge amounts of data from communications that is meant to be outside the country or between a South African and someone outside the country. But as the SSA acknowledged in its own papers to the High Court, the SSA is unable to distinguish between local communications and foreign communications because of the technicalities of modern communications. So as a result, it's highly likely that the communications of perfectly innocent South Africans who aren't suspected of any kind of crime have landed up on some state database somewhere. And this is precisely what the Constitutional Court is pointing out as being unlawful. There's no law giving it the power to undertake dragnet surveillance along the lines of what we've seen Edward Snowden complaining about when he disclosed the abuses in the US and the UK.
Would we have any idea as to how widespread this dragnet scooping of information was, Jane?
We don't know what the capabilities of the National Communications Centre are. I would suspect that they are unable to operate on a collected-all basis because even the mother of all signals intelligence agencies, as they're called, the National Communications Centre, is unable to do that. But I think it's safe to assume that the NCC, in addition to collecting and analyzing huge amounts of communication data from outside the country, has also been surveilling us too, South Africans. To what extent is anybody's guess? That's part of the problem.
Could you fill in this little puzzle piece for me then? What does it mean for journalism in South Africa and reporting?
Well, I think if we look at the judgment as a whole, I think it's huge for journalism. There are special procedures now that are required by the Constitutional Court on an interim basis. If the RICA judge grants a warrant or an interception direction against a journalist, but also a lawyer as well, this particular matter needs to be brought to the attention of the judge that the interception direction concerns the communications of a journalist or a lawyer. It also means that the National Communications Centre can't be used as a way of getting around the RICA process in order to spy on journalists and lawyers. Exactly what that will look like and what special provisions will be put in place to protect the confidentiality of journalists and lawyers' communications remains to be seen as RICA is redrafted by the Department of Justice.
And that's going to take quite a few months. In the meantime, though, it's all very well to have this ruling, but I would imagine down the line enforcement could be quite difficult.
Enforcement may well be difficult, and I'm also quite concerned about the fact that the Department of Justice is being granted a whole 3 years in order to get its act together, bearing in mind that it's been saying for 4 years already that it recognizes that RICA needs to be reviewed. So it has recognized for a long time now that RICA is a problem. I'm also a little bit concerned that there may be unintended consequences and that remaining loopholes in RICA could potentially be exploited by the spy agencies. So, for instance, there's nothing stopping the spy agencies from entering into an intelligence sharing agreement with another country and getting that country to collect on its behalf, including on South Africans. It's possible that state spying will now be driven underground and more private sector service providers may be used. And also, a very big loophole in RICA is that metadata or data about our communications can actually be given to the spy agencies on a very loose provision in Section 205 of the Criminal Procedures Act. And I suspect that they're going to be using that a lot more than they will RICA.
And I'm going to thank you for joining us from the University of Johannesburg, Professor Jane Duncan. Thank you very much indeed.